My main areas of interest are in legal philosophy. The words tend to be interchangeable: legal philosophy, jurisprudence, legal theory. But here at LSE we teach a course on jurisprudence, which means the philosophical investigation of the concept of law. A debate that's run throughout legal philosophy for centuries is the debate between the philosophers of legal positivism and philosophers of what we would call natural law. A positivist legal philosophy concentrates on what is posited, law as enacted, as explicit. Its priorities are that we know what the law is, that law is clear. A feature of positivism, which is critical for distinguishing it from the natural law crowd, is that the positivists insist that law is not referable to any kind of extraneous moral idea. It's a question of social fact. Does it or does it not exist is something we can verify just on the facts. We don't need to put it against standards like morality. The natural lawyers have always departed from this, but in different ways. Their main claim is that law has some kind of important moral dimension. They insist that the positivist legal philosophy doesn't exhaust our understanding of law. There's something more to it, and that something more introduces some important moral characteristics or dimensions to the concept of law. So in the 20th century, this debate between positivism and natural law was probably most famously captured in the 1950s by a debate between an Oxford legal positivist philosopher, H L A Hart, who became by far and remains one of the most important figures in 20th century and carrying through to 21st century legal philosophy. He debated questions about law and morality and whether they are in fact connected or not, whether law has some inherent moral content, with a Harvard legal philosopher called Lon Fuller. This debate, it took place in the 1950s. We could say, why does this matter to us now? But it's been a debate that students of jurisprudence have looked at literally for 50 years, to the extent that at the 50th anniversary of this exchange, there was a great explosion, one might say, of interest in the debate again. It's symposia held across the world and so forth, indicating that the questions that these two are getting at remain salient for our concerns today. And the natural law position in that debate was somewhat different to what we would ordinarily associate with the position. It wasn't about evil law can't be law because it's immoral. It was instead about whether law includes some kind of moral criteria that go to the form through which it's expressed. Or put differently, whether the form through which law is expressed, whether the rule of law imports some sort of moral connection to law. Are the two so closely connected that morality creeps into law through the moral value of the rule of law? And that sounds a little bit obscure, so just to explain one of the focal points of that debate, which was a discussion about Nazi law, where Hart, defending legal positivism against this claim that law and morality are not necessarily connected in any way, was taking on the question of whether Nazi laws of particularly evil characteristics could or should be given the title of law. And his argument was, consistent with the positivist tradition, that if these laws were considered valid by Nazi officials, then they were valid laws. Their moral content is a separate question, something for us to get terribly distressed about at a political or a moral level, but it doesn't go to the question of whether they were in fact law. Fuller's response to Hart, which brings us to the rule of law connection, was look at the way the Nazis convened their legal system. Look at the fact that you had serial instances of retroactive laws. You had secret laws. You had modes of interpretation where the judges gave decisions or interpretations of the law that bore no logical relation to the actual text of the legal enactments. Various criteria that were extremely disorienting for those that were subject to the law, and which in Fuller's view called into question whether that system could be as a whole given the title of a legal system, whether in these instances of formal debasement you could actually say that something called law still emanated. So why that debate is interesting is because it's traditionally understood as a debate about are law and morality connected. But the way I read it is that Fuller is asking Hart, he's asking positivists to explain how much does the rule of law matter to your concept of law? Are you willing to look at an instance of Nazi legality which is retroactive, where they kept the laws secret from their subjects, where the letter of the law was abandoned whenever the officials saw fit. Are you willing to look at that and say it's still law? So he's asking the question of whether, as legal philosophers, we are content to have such an undiscriminating notion of law just because certain officials in a system say, this is law, we're going to call it law, so you must understand it as law. Does this matter? Do these sort of aspirations of what we think law should be in terms of its form, do they matter to the concept of law? And I think that this is still relevant because in, for instance, recent developments in the war on terror and various legal developments that have been associated with that, what we've seen is instances of secrecy, of evidence being withheld from defendants, of aspects of the way this has been handled that we've reacted to not necessarily or primarily against their content, but because we think that that's not how we do things. These are questions that I think are fascinating because they're theoretical questions. Theoretical questions such as how clear do we need our concepts to be? And the concept of law should be a clear idea. We need to know what the law is. But there are also practical questions, which is what quality of legal systems do we want to grant the title of law to?